that and be able to
Yes, Your Honor.
to see what other courts have dealt with on that. On Kyle C. Whitley,
514 U.S. 419. The quote was 437 through 438, 1995 case about affirmative duty. And I have no reason to believe that case mentions workers' comp cases. It deals with exculpatory favorable evidence. My argument as to the statute, North Carolina statutes, if he's injured and there's documentation about his injury, then that's discoverable under the discovery statute. I don't have it in front of me, but that seems pretty clear. Brady versus Maryland, your Honor knows that one. United States versus Augers is 427 U.S. 97, 1976. And I could go through some memos that I filed earlier to find other support for this. I would also argue the North Carolina Constitution, the Declaration of Rights, Article 1, would also provide support for the prosecutor having this affirmative duty. As you know, Your Honor, the North Carolina Constitution provides, in some cases, and can provide more rights than the U.S. Constitution, not less. So I would also cite the North Carolina Constitution for that proposition. But I think Kyle C. Whitley is a good starting point for that quote about their affirmative duty to learn of favorable evidence. It's not what's in their file. She knows that. Everyone knows that. This is 1995 quote. That's from a long time ago. So that would be my cite to the court for their starting point.
all right. Thank you, Mr. Charles. Yes, Ms. Ellen?
Your Honor, just in reading the overview of Kyles v. Whitley, it deals with evidence favorable to the state where the state failed to disclose that information. Your Honor, once again, the state has not failed to disclose information because we don't have it. There are several cases on point, and I'll be able to pull those and provide those to you that the state does not have to supplement our prosecutorial files at the whim of the defense attorney. I have prosecuted numerous cases and never had a request made for any workers' comp cases. I am not a civil lawyer. So, Your Honor, that's basically what I would say, that this case is very, very different from our case in that this case, Kyle's, deals with an alleged non-disclosure of information that they actually did have in their file.
Well, the question is going to become whether workers' comp, and the alleged victim is an employee, whether there's a workers' comp case involved, and is that part of material that is that material that's part and parcel to the prosecutor's requirement to produce under Brady beneficial information, exculpatory information, and that's going to be kind of what the issue here is. And it would seem that would be an issue that would arise across the United States somewhere. So, yes, Ms. Strong, you're on.
Yes, sir. May we have a brief recess to research that particular issue and find out whether that is indeed the case and whether or not it is discoverable, and provide the court case law that would deal specifically with that issue, if such case law exists.
I've got Mr. Welty on speed dial.
Thank you. Yeah, if y'all stay right there. Yes, Mr. Jones.
Connor, I would ask that decision be made at a time when we're not holding the jury up, that in terms of this evidence, they can have their bevy of helpers research this and come back and give that to us. I don't have anyone to help me. I don't have anyone in my office to put on the record other than Mr. Donovan. There's two of us. Two. He's not assigned to this case. He's in another courtroom. So I would ask that we don't research this now. I've raised this issue because it's an important issue. They haven't arrested yet. I would ask on the motion to dismiss, I can briefly give an overview, or we can do that later as well. I don't want to keep the jury waiting there. I guess I didn't anticipate this was going to take as long as it's taking, but in any event, it's your Honor's discretion to do this now, do it later. My vote is to have the jury hear some evidence, and there's going to be a stopping point where they're going to come in with all their evidence why they don't have to search other files. That's not the law. It's not the Constitution. That's not the way we do things, except in Durham. So I'm happy to go on to the motion to dismiss to give you an overview, or do that later. But it's putting the pieces together, and it could be done at a later time. My preference is to have the jury start hearing some more evidence, and we could, at a good breaking point, go over all these things once they do some research. I did my research.
Thank you. Anything else anybody wants to say?
Your Honor, I understand that the jury is waiting. However, he has brought up issues that need to be addressed. He is basically stating that there is prosecutorial misconduct and making a motion to dismiss. And at this time, that needs to be addressed in the eyes of the state. I do defer to the judge, however, but these are serious accusations, so we would ask that they be resolved at this point to find out if we are going to put on further evidence in this case, Your Honor.
Thank you. I'll be with y'all in just 1 moment.
Just to note for the court, my client took a brief comfort break. He should be back in a matter of seconds, if not minutes.
Thank you.
Yeah.
text from the appellate defender's office
What's that?
about this issue. They were calling School of Government, and someone on my behalf contacted Dan Schatz at the appellate defender's office.
All right.
And what this kind of is putting the records before the determination there are records, but assuming an officer wants to be compensated, they would file a claim. And it says, quote, Schatz says judge should examine in camera for exculpatory, end of quote. Certainly that's what was done with internal affairs files, and whether those workers' comp files originate in the police department or somehow are stored at City Hall. Your Honor, it's the same analysis. And Cosby-Whitley is a capital case, and those of us who do capital post-conviction cases argue all the time, and that's where this came from. It's not what they have in their files, the prosecutor's files. That's not the analysis. If it were, the prosecutor would not keep many things in their files. They have the affirmative duty that Cosby-Whitley speaks of, and that may be, in a capital case, it might be social worker files, it might be psychological files, but certainly workers' comp, the officer has made statements about his medical condition. He's made statements about presumably how this came about, potentially, but I'll sit down now, but I just wanted to make you aware, since it's the battle of who outside is going to tell us what the law is. When we have Cosby-Whitley, it's pretty clear. It doesn't talk about workers' comp, but exculpatory is exculpatory. And if she doesn't know what's in there, didn't even ask the gentleman. I haven't seen anyone turn around and ask him, did you file a workers' comp complaint? Are there claims, medical claims that the city has that haven't been provided? What we have is the Duke records, we have the EMS records. We don't have anything else. In fact, as Your Honor may recall, we had a hearing 2 years into this case where the prior prosecutor told me, I released the medical records to you. Don't you remember? I said, no, you didn't. I have all this stuff. We didn't get the color photographs from the crime scene investigators and the medical records in this case until very late in the game. The other lawyers didn't receive them. Despite, I believe, the good faith of the prior prosecutor, she thought they had been released. There's voluminous records in this case. So at this point, I'll sit down unless you have a question, but just to let you know, according to the regional defender, who kind of is not really my boss, but supervises me, she contacted the appellate defender, and that was Dan Schatz, who's an assistant appellate defender, used to be a public defender in Durham.
And said what?
Said the judge should examine those records in camera. So that is hearsay about a legal opinion. But I'm just reading you the text, and they can move to strike that, but that's the text I received. That was my legal research beyond quoting you Cosby-Whitley and their affirmative duty that should be well known to all prosecutors across the country. Your Honor, if this motion is denied, I'd like to briefly do a voir dire with Officer Stewart about what records exist. It'd probably take 5 minutes to just get to the bottom of this. In fact, we could do that now, do a voir dire.
All right. State, have anything else you wishes to add?
We do not, Your
Other
Honor.
than you'd like a recess to...
We would like time to respond. Yes, sir, Your Honor.
Sheriff, if you could tell the jurors that we'll be in recess until 11 o'clock, and that way everybody will have an opportunity to do some research here, and when we come back, we're going to come back, well, we'll come back at 10 minutes until 11. That's when we'll come back into the courtroom. jury's free until 11 o'clock. By the time we come back, I want to hear motion number one. What are your arguments on motion number one, motion to dismiss for prosecutorial misconduct? I don't want to go through hours or days more of evidence if that's determined to issue. The roll. We kind of made an allusion to the redaction, but we'll address that as the issues come up. The motion for sanctions, I'm reserving for later. The motion in limine regarding redaction, we'll cross that bridge if the evidence is presented. And the Brady material claim, that's the one I'm also going to hear some of your motion to dismiss the prosecutorial misconduct allegations and whether Brady contemplates workers' compensation claims and records as part of the duty of the prosecutor to go out and locate those records, and if it's something exculpatory, making sure it's furnished to the defense. So we'll be in, our group in here in court will be in recess until 10 minutes until 11. The jury's free until 11 o'clock. We'll recess, just tell them.